screen go. All right. So let's see, where's my control? Share screen. PowerPoint. All right, so you should be looking at the PowerPoint now. We are here to talk about mechanics liens in Virginia, Maryland, Pennsylvania, and the District of Columbia. I am a big believer that 80% of mechanics lien law is the same in all states, in my experience. We have to be very careful about providing legal advice in a state where we have no experience and no license, because there is that 20% difference. But the majority of mechanics lien law is the same in all states. So I think it's beneficial and less confusing to spend most of our time talking about the similarities, the things that all mechanics lien laws in all state have in common, and then focus on the half dozen places where they are different. And no question, those differences can make a big difference. And it's important to understand what state you're in. And we're talking primarily about the priority of the mechanics lien, which sounds very lawyerish, but hopefully you'll be comfortable with that by the end of the morning. The priority of the mechanics lien, whether or not there is a defense of payment, whether or not there's double jeopardy, are the two major differences. And those differences are most striking when you compare Virginia and Maryland. Those are two places that those states are very different. And the Maryland lien law is generally different from most mechanics lien statutes in the country. It used to be very similar to Virginia's law. There was a major constitutional challenge in the 1970s, 76, I believe it was. The legislature in Maryland made radical changes. The constitutional challenge was that the mechanics lien was a taking without due process, that a mechanic could just go file a mechanics lien in the land records without, and the property owner would have title to their property clouded without getting their day in court. And the court never ruled on that, but it shook up the legislature enough that they completely revamped the statute in a way that is generally not helpful to people like you, not helpful to claimants. In any event, we'll get into that in a little more detail. You'll see it says here chapters 9, 10, 11, 12, and 13. Those are references to my book. And you'll see in the lower left-hand columns numbers sometimes that gives you a chapter and page number where you can find more detail on what we are talking about. Here, this is my name, firm name, our address. We're in Clifton, Virginia. Here's my email. You are welcome to call or email me anytime with questions. But I did want to point out particularly the website here, and I'll take you there for just a moment to show you. Let's see, share screen. Where is, okay, so that is the homepage of our website. If you hit this picture of the book, is one way to do it. It takes you to the table of contents of the book. Today, we are talking about chapters 9, 10, 11, 12, 13. Later this month, I believe it's October 27th, we're going to have a separate conversation about performance and payment bonds, which will be a little shorter. And then I think early November, maybe the 17th or thereabouts, we're going to do chapter 2, contract terms and preserving rights. But today we're going to do a little bit of an introduction to all of those subjects. There are appendices at the end of the book. Here at the beginning concern the contracts, and there are some contract forms you can use there, change order forms, UCC financing statements, promissory notes, and that sort of thing. But towards the end, there are mechanics lien notices. The form mechanics liens are supplied by the legislature in most states. In Virginia, for example, the Code of Virginia has a mechanics lien form for general contractor, have one for a sub, have one for a sub-sub, and those are appendices to the book. This is another place you can get them. And you can see that about half of the book is mechanics liens and payment bonds. It's about 350 pages, and it is the most detailed book in existence on mechanics liens and bond rights in these states. Okay, let's switch back our screen again. Let's see. All right. So I like to, well, we did that. Okay. I like to start a discussion of mechanics liens by talking about why it matters. Why is it important? And you can see here, this is on beginning of chapter 9. Chapter 9 is general mechanics lien principles in all states, which would include this discussion. 1 year adjustable rate mortgages now are a little under 3%, 2.5%. You can borrow money at that rate, whereas credit card debt carries 15 or 18% debt. Even if you're paying your credit cards in a timely manner, even if you're not past due, they're charging you 15, 18% usually. Sometimes you can get it a little bit cheaper. Why is that? Both of these business people are selling you the same thing, the right to hold $1 for a year. How come this lender, the credit card lender, charges you 5 or 6 times as much to hold that $1 for a year? They have the exact same costs of production, the exact same costs to provide that $1. How come this guy charges that much more? The answer is security, which many of you are thinking about. But why does that matter? This lender has collateral or has security in your house. If you do not pay your mortgage, they can sell your house and keep the proceeds of that sale in order to pay their debt. This is an unsecured creditor with the credit card debt. Why does it matter? The secured lender has less risk of a complete loss. Certainly, that's a big feature. Do people ever default on mortgages? Sure. We learned, especially in the subprime loan crisis in a little over 10 years ago, there were lots of defaults on residential mortgages. And in that instance, there had been way over inflation of property values and hyper lenders willing to lend to borrowers who weren't that well qualified. So weak borrowers were borrowing way too much money, and it was a true crisis. Those lenders lost lots of money, and a lot of them went out of business. But those lenders still, even in those conditions, they were still recovering more than half of what they were owed, whether it was 60%, 70, 80% of what they were owed. And I would respectfully submit to you that that's a lot different than the complete loss that the credit card lenders took in the same crisis. The same debtors that were defaulting on their mortgages were also defaulting on their credit card debt. The credit card lender ended up getting zero because the secured lenders got everything. The secured lenders got 50, 60, 70% of what they are owed. And in this market, one interesting indicator of how strong the economy is, at least pre-pandemic, 3 years ago, say, that the typical mortgage lender, residential mortgage lender, if a house went to foreclosure in Fairfax County, Virginia, it would, at a foreclosure sale, it would typically bring 98% of its fair market value in a foreclosure sale. Very striking difference from the subprime loan crisis we were talking about a moment ago. I'd be interested what the answer is now, and I don't know. We probably won't know for a while yet. But so there's much less risk of a complete loss for a secured lender. But most people understand that. But the other thing I would like you to really focus on is that there is less risk of a default also. What's the first debt? What's the first bill mom and dad pay every month as they're splitting up their paychecks and deciding what debts to pay? The first debt they pay is the mortgage. They know they're going to have to pay that lender. That lender has the right to foreclose upon their home. They'll have nowhere to live. The debtor is highly motivated to get that debt paid. And that's what I call leverage, a term I will use a lot in this seminar. This lender has a lot of leverage on the debtor, which is another way of saying the debtor is highly motivated to pay this debt. So there's less risk of a default and less risk of a complete loss for this lender. And that means this lender has lower cost of doing business and can charge 1/5 or 1/6 of the dollar amount that this lender can charge. Credit card lenders really need 15 or 18% to stay in business, to make any money. They will be losing money otherwise. What if the rate for all lending was set at 10%? Maybe some legislation is passed saying that it's un-American that if you own a house, you can borrow money at 3% interest rate. But if you don't own a house, you have to pay 15 or 18% interest rate. That's discriminatory. That works to the disadvantage of people who cannot afford houses, and it's un-American. We're going to say all lending has to be at 10%, whether it's secured or unsecured. How's that going to work out? Who's going to like that? Who is not going to like that? The secured lenders are going to love that. In fact, it was probably their lobbyists that were walking the halls of Congress talking about how un-American it was, the 3% interest rates on secured lenders. They now can charge 3 times as much for the same product, triple their profit with no increase in their cost of doing business. Who is going to have a problem with that? The credit card companies will be put out of business by that. What if the rate for all lending is 0%? How's that going to work out? Well, it's not going to work out real well for anybody. Both the secured lenders and the unsecured lenders will both be hurt by that. They'll both lose money, but the unsecured lender is going to lose a lot more. And what I want you guys to realize is that the people in the audience, this is the rate that you lend money at. You send tens of thousands of dollars out the door every day. You're lending money every day at this interest rate, 0%. If you get paid within 30 days at 0% interest, you're thrilled. If you get paid within 60 or 90 days at 0% interest, you're pretty happy. If a debtor calls you with a 6-month-old debt and says, I tell you what, I can pay you 100% of principal today, but no interest, no attorney's fees, but I'll have a check there tomorrow if you'll take that, you'll probably make that deal, depending on whether you have any security and other factors that we're going to be talking about. So when you are in a business, what I'm suggesting, when you are in a business where you don't even get 3% interest on the money you lend, whether or not you are a secured creditor in that transaction has a huge impact on your cost of doing business in that transaction and has a huge impact on your profit in that transaction. So people often think about mechanics liens in terms of, okay, the debtor's now in default. What do I do? Where do I go? Where do I file my mechanics lien, et cetera? And it is important to know that. It is important to understand that. But what I am stressing and what I hope you guys really get out of this seminar is that your status as a secured lender, the question of whether you have strong mechanics lien rights or strong bonding rights determines what your cost in doing business will be in this transaction. If you are well secured, you have the ability to sell product at a lower price without impacting your profit, or to say the same thing in reverse, your profit's going to be much higher on a project on which you're secured. So I really encourage you to think about your mechanics lien rights as you are qualifying a project, as you are thinking about bidding on a project. I don't know how anybody can bid on a project, for example, without knowing whether or not the project is bonded, whether the general contractor has provided a bond on the project. Your cost of doing business is significantly lower if it is a bonded project. Okay, let's think about, well, here, let me digress one more second. What is the last debt mom and dad pay each month out of their, and I can remember I used to be a bricklayer and I'd get my paycheck every Friday and I would sit down and I'd mean to pay all my bills, but I would have a list of, my regular bills on a sheet of paper and I would decide what order to pay them in. And I'd have a list, how much I owed, what the due date was. What's the last debt you pay? Some people may be thinking credit cards, but I would suggest to you that no, it's not credit cards. The last debt I'm going to pay is my doctor bill. I love my doctor. I want my doctor to take good care of me. I want him to be motivated to help me. But my doctor did not even make me sign a credit application. My doctor is not going to charge me late fees. My doctor cannot make me pay their attorney's fees because they did not make me sign a contract saying I would. And so if what I'm suggesting to you is what we've covered most of the morning so far, is the issue of security and how that motivates debtors to pay and how that lowers your cost of doing business. But what I'm suggesting now, that your contract terms play a similar role. If I fail to pay my credit card bill, that lender is going to charge me a late charge. They're going to charge me 24% interest on the unpaid debt if I default and miss a payment. And I know they're going to charge me, and I know I'm not going to be able to talk them out of it. And so that motivates me to pay the credit card before I pay the doctor bill. So that's an introduction into what we're going to talk about in November about contract terms. Its contract terms aren't all about lawyers making money. Contract terms are about motivating debtors to pay, getting leverage on debtors and motivating them to pay you in a timely manner. Okay, so let's think about the last time you bought a house. You were asked to sign multiple sheets of paper. One sheet of paper was a promissory note. That's the sheet of paper that said, if you give me $300,000 today, I will pay you $3,000 a month for the next 30 years. That's the promissory note. It is signed by the contract debtor. If the debtor fails to keep that promise, the person who signed this promissory note, the contract debtor, the creditor can sue that contract debtor and obtain a judgment. And this is chapter 17 of the book, enforcement of a judgment. This is an unsecured creditor, has no security, has only a contract. They obtain a judgment in court. Now this creditor will get the aid of the court in enforcing that judgment. That creditor can file a garnishment when bank accounts. The creditor can docket the judgment on real estate owned by the debtor, and that judgment will become a lien on the real estate. And that's the short version, theoretically what happens when you are enforcing a judgment is you're identifying, you're finding assets of the debtor. You are attaching your judgment lien to that asset, and then you foreclose upon that asset, much like a mortgage lender will foreclose. The difference is a mortgage lender always had a lien on the real estate from before the time they lent the money. The unsecured creditor does not have a lien until they sue the creditor, obtain a judgment, and then can find an asset to enforce that judgment. So the second sheet of paper you signed last time you bought a house described a specific asset, your house. And this contract is signed, this is a mortgage, this contract is signed by the owner of the property, who might be the same person as the contract debtor, but doesn't have to be. The owner of the property agrees in writing that if this contract is breached, if the contract debtor does not pay this debt on time, the lender can sell this real estate, foreclose upon the real estate, and that lender will get all of the sums of money that sale brings until that creditor is paid in full. If there's any money left, other creditors of the debtor can obtain those funds. Okay. Your contract to supply labor and materials is very similar to this promissory note. A note is just a type of contract. A note is just a very simple contract that says, you give me $300,000, I'll pay you back so much per month. Your contract's a little more complicated. It's got plans, it's got specifications, it's got a lot more details about your performance, but they are both unsecured promises to pay signed by the contract debtor. They both allow the lender to sue the debtor and obtain a judgment, and then attempt to enforce that judgment by finding assets of the debtor. What is a mechanic's lien? A mechanic's lien is one of these. It's essentially it's very similar to a mortgage. And a lot of people are surprised to learn how similar to a mortgage a mechanic's lien is. As a matter of fact, in the Maryland Code, and the Virginia code, the procedure to foreclose upon a mechanic's lien and a procedure to foreclose upon a mortgage are very similar. I mean, it's the same code provisions. It's identical. The difference between a mortgage and a mechanic's lien is with a mortgage, there's rarely an argument about whether or not the lender has a lien. The only argument is about priority and whether there's enough value in the property. Whereas in a mechanic's lien, in true mechanic's lien litigation, a lot of people are fighting about whether or not you have complied with the mechanic's lien statute, whether or not the creditor has a lien. And that's because true mechanic's lien litigation is a battle between multiple creditors of the lender over priority. Who's going to get the proceeds of that sale? So mechanic's lien rights are given to you by the legislature. The property owner has not agreed you get a lien. The Code of Virginia says that if you provide labor and materials to a piece of real estate for construction of an improvement and you do not get paid, then you will have a lien on the property and you can foreclose upon it as long as you follow the rules, which is what we're here today to talk about. Now, and to fast forward to a few weeks from now, there is one more sheet of paper that you often use in your transactions, or you are required to provide in your transactions, and that is a personal guarantee. A personal guarantee is signed by debtor number 2. For our purposes right now, what I want you to focus on is that a personal guarantee is one of these. It's a contract. It's just another type of contract. The significance of a personal guarantee is it's different debtors. Debtor number 2 agrees in this contract that if the contract debtor defaults, if the contract debtor does not repay the lender can go against debtor number 2 and force debtor number 2 to pay. And that is very helpful to a creditor if debtor number 2 has more money. Will you always be paid if you have a personal guarantee on your debt? No. If you're doing business with a small, closely held corporation, if the business becomes insolvent, they probably won't even bother to file bankruptcy. They'll just close their doors and stop doing business. And you won't be able to enforce your contract because you're not going to be able to find any assets of the business that went out of business. But if that happens, there's a good chance that the president of the corporation, the guy, depending on how many personal guarantees they signed, the president may file bankruptcy because they want a clean bill of health so that they can reopen the same business with a very similar sounding name at the same address and go back into the same business they were in before. And they're allowed to do that. In other words, if you're doing business with somebody whose last name is Inc., Corporation, or LLC, you just have to know that. You're going to be paid only as long as this contract debtor remains in business. If they become insolvent and don't have any assets, you're not going to get paid. That's the deal. Okay. Now, the main reason I bring this up right now is to explain that that this is what a payment bond is. A payment bond is a type of guarantee. A payment bond is a guarantee signed by the general contractor on the project and signed by an insurance company, promising that if you do not get paid on the project for the material you are supplying, that you can pursue the general contractor and you can pursue the bonding company, usually an insurance company, for payment. It's really the same as a guarantee. The big difference is debtor number two is usually a big financially strong insurance company, and they're not going to be able to file bankruptcy like the president of the small, closely held construction company will be able to do. Okay. So what is a mechanic's lien? It's really very similar to a mortgage. It allows the lender to foreclose upon a specific piece of property, foreclose upon the real estate where the improvements were constructed. You will be, if you have mechanic's lien rights, you will be a secured creditor in bankruptcy. That's another whole chapter of the book. But in the event of bankruptcy, whether or not you're a secured creditor will typically dictate whether you get paid in a bankruptcy. The general rule in the event of a bankruptcy is the secured creditors get paid, the unsecured creditors get nothing. And if you have established your mechanic's lien, you will be a secured creditor in bankruptcy. Now, when and how you become secured, when and how you establish your mechanic's lien is what we're going to spend the rest of the morning talking about. That's the issue of priority, and the priority of the mechanic's lien is going to determine when you are secured and whether you will be paid in the event of a bankruptcy. All right. A mechanic's lien gives the lender two avenues for collection: contract rights and security rights. You have the choice of suing the debtor on the contract, and you have the choice of establishing and enforcing your mechanic's lien rights. Okay, so I encourage you to prevent losses by preserving security rights. Think about that as you're going into transactions. Make sure that you will be a secured creditor in this transaction and not the credit card guy. You need to qualify each project just like you qualify each customer. There's for various reasons that we're going to spend the rest of the morning talking about. Your mechanic's lien rights will be weak in certain circumstances, or they'll just plain be too expensive to preserve and enforce. And I want you to be thinking about that as you're entering into the transaction. If your mechanic's lien rights are going to be weak and there's no bonding rights, you need to focus a lot more on the financial strength of your contract debtor. You might need to investigate further, get additional references. You may need to ask about the personal guarantee or some other type of security for this transaction. And this basically comes down to collecting information on each project before you bid on the project. You have to know your cost of doing business before you bid on a project. Whether or not you're a secured creditor will dictate to some extent your costs. And before you ship to the project, you want a copy of the building permit, a copy of the site plan, a copy of any payment bond. You need to know the name and address of the owner, the name and address of the general contractor. Now, you're going to be able to get this information to varying degrees on different projects. And sometimes these details matter more and sometimes they matter less. These are simply examples of information you want to collect before shipping to the project, because if there's been a problem on the project and you are not getting paid, it's going to be much harder to collect information. If your debtor's 90 days past due on your debt, and you call your debtor and say, hey, do you mind giving me the name and address of the owner on the project? That's not going to work. This is information that must be collected before shipping, before there's a problem, and while your customer still needs you. A good way of going at this is Appendix 4 from the book, which you can get from the website, or I can email to you if you want it. This is what I call a project information sheet. And you're only going to have part of this information on any particular case, but it's a good checklist of the information you need to collect. This probably the single most important, and what you really do need on every project, is the owner's name and address, the general contractor's name and address, the street address, some kind of description of the property, at least a street address. If you have a copy of a site plan or a building permit or a tax assessment, that's even better. That's an easy way to collect information on the property, but you at least need a good description of the property. If you want my help filing a mechanics lien, I'm going to need to know the type of structure. Is this public or private? Is it a road, site improvements, swimming pool, drainage structure? Is it a house? What is it? What was the improvement? And the name and address of the surety, a copy of the payment bond is even better. And it's going to be difficult to get a copy of the payment bond on a lot of projects. But I want to at least ask you to focus on whether or not this project is bonded. That's a very important question. And that often comes down to whether or not it is a public project. That'll be what we'll talk about later in the month in the payment bond chapter. This list of items under number 9, these are documents I need to make a claim. So you don't really need to collect what's listed under number 9 until there has been a default. But clients, if there's a problem, clients always want me to tell them, well, what do you need from me to file this mechanics lien? Well, here's your list right now. And I will often just email this project information sheet to clients and ask them to fill it out. And that's how to start the project. But what I'm suggesting now is this is a good checklist for you to think about before you ship, before you lend money, because it's going to be much easier to collect information before you ship. All right, so let's talk about deadlines and timelines. And I'm doing this in chronological order. Some states, in order to preserve mechanics lien rights, some states require some sort of notice before you ship or very early in a project. Florida and California are 2 examples of states that have notice to owner statutes. In the 4 states I deal in, and we're talking about today, early notices appear 2 places, Virginia and Pennsylvania. Virginia has what's called a mechanics lien agent notice. It is a pre-registration on residential projects only. It only applies to residential projects. It is important to understand it does not declare a default. You're not saying anybody is past due in payment. You're pre-registering on the project. You have to send a notice that you will be supplying labor and materials to the project. It does not apply to commercial projects. It does not apply to subdivision improvements. It only applies on the construction of a home in a residential project. You will have no lien rights if you do not pre-register. In other words, I think a good way to explain this is to compare it to Florida's notice to owner statute. In Florida, I believe on any construction project, you must send a notice to the owner before you do any shipments. And if you send the notice to the owner before you supply labor and materials, the owner now has the burden of making sure that you get paid. And if the owner does not make sure you get paid, you can make the owner pay again. Even if the owner has paid the general contractor in full, a subcontractor or a supplier can make the owner pay again. That's extremely powerful, and it motivates owners to police the project very carefully and make sure that everybody gets paid. It makes it more likely an owner is going to require payment bonds or some other way of ensuring they will not have to pay twice. And I'm explaining all that to amplify how different the Virginia Mechanics Lien Agent notice is. It puts no additional burden on the owner. It creates no additional obligation in anybody. It has only a negative effect. You will have no lien rights if you do not pre-register, but it does not put any burden on the owner to make sure that you get paid. The notice must be mailed to the Mechanics Lien Agent. Where do you find out who the Mechanics Lien Agent is? It's on the building permit. Every residential construction project in the state requires a building permit. There is a place right on any building permit in Virginia that says Mechanics Lien Agent, : and after that, there's going to be a name and address, usually the name and address of a title insurance company who has provided insurance to the bank, insuring against mechanics liens on the project. But the Mechanics Lien Agent could be an attorney. I have acted as a Mechanics Lien Agent before. It could be a bank, but it is usually a title insurance company. But you don't need to know who it is. The point is, on the building permit, it says Mechanics Lien Agent. If there's a name and address, you must mail a notice to that Mechanics Lien Agent within 30 days after you begin supplying labor and materials on the project. You can find more detail on this in chapter 10 of the book, starting on page 4. I'm not going to spend a lot more time on it since it only applies to residential projects. But if you are working on a residential project, you must get a copy of the building permit. You must see whether there is a Mechanics Lien Agent, and you must send them notice, certified return receipt requested within 30 days after you begin work. It's an easy test to pass. Everything that is required on the Mechanics Lien Agent notice is either on that building permit or it is in your own file. You have to say, accurately give your name and address. You have to say who you are supplying labor and materials to. But the main key, you have to provide the description of the property that appears on the building permit. And so if you have a copy of the building permit, you can prepare this mechanics lien agent notice yourself. I do provide a form in the appendices on the book that you can fill in the blank and send it in. But it can be in a letter form. No precise form is required. There's just certain information is required. Okay. Pennsylvania also has a notice to owner statute. It is similar to Virginia's in that it does not put any additional burden on the owner to make sure that you get paid. It does have one feature that's better than Virginia from a claimant's point of view, however, and that is this website. This government-funded website has a central database that tells you whether or not a notice is required on this particular project. For certain projects in Pennsylvania, searchable projects is just the word they use, and that is a project that's over $1.5 million. So it's only on larger projects. The owner can file a notice of commencement on this website that says we're starting construction. If the owner files a notice of commencement, you must file a notice of furnishing. If a notice of commencement is filed, you have to file a notice of furnishing within 45 days of first performing work. That notice is also filed in the construction notices directory. It does not declare default, but it does not create any additional burden on the owner. The big difference is that you can search this database much easier in Pennsylvania. In Virginia, there's no requirement, there's no public, well, the only way to find out, get a copy of the building permit, and the only way to find out whether a mechanics lien agent has been identified is to go to the building department in that county and look at their file, look at the building permit. And most, really all counties in Virginia nowadays, they have at least one person that it's their full-time job to just answer the telephone when people like you call and ask whether there's a mechanics lien agent on the building permit. Some of these building departments are more efficient than others. Some of them, it's relatively easy to get mechanics lien agent information. Some of them, it's quite difficult. So in Virginia, you're really better off requiring your debtor to send you a copy of the building permit before you agree to furnish materials, particularly if you're a supplier. If you're a subcontractor, you should have a copy of the building permit in any event. Okay, so the big difference in Pennsylvania is that this central website where you can go get information. All right, so those are the only pre-notices. There's no pre-notice in District of Columbia. There's no pre-notice in Maryland. All states, however, have some type of procedure after you supply labor and materials in order to preserve your mechanics lien rights. That deadline, I encourage you to remember Fullerton's rule. My rule is that you need to move within 90 days after your last new contract work. Emphasize last new, it's got contract work, and we'll talk about the significance of those words in a few moments. The 90-day rule I like to use is the lowest common denominator. It will cover you in Virginia, Maryland, Pennsylvania, and DC, whether you're talking about mechanics lien rights or bond rights, as long as you move within 90 days after your last new contract work, you're okay, with very few exceptions. There's really only 3 exceptions. One we've already discussed, and that is the pre-notice requirements in Virginia residential projects and in Pennsylvania searchable projects. We will talk about a few other exceptions over the rest of the morning. One is the defense of payment. That's one reason the defense of payment is very important. Another is subdivision improvements in Virginia, but we'll get back to that in more detail. But in all 4 states, the general rule is you got to move within 90 days of your last new contract work. In many instances, you will have more time than that. But I encourage you to just remember the 90-day rule and set up your systems to help remind you to move within 90 days of your last work. Now, when has your last work occurred? That was one of the significant words in the last new contract work. When has your last work occurred? What about punch list? What about warranty work? I encourage the rule that repair and warranty work does not count, does not extend your deadline. Now that is a lowest common denominator rule. And what I'm thinking of is payment bond litigation. Federal payment bond law is very clear that repair and warranty work does not extend your time to make a bond claim. I am not aware of a court case in Virginia state court or in Maryland state court work saying that repair and warranty work does not count. But in all these kind of deadline rules, I encourage you to be safe. Use what I call the lowest common denominator. Don't even give people an argument that you were late. Because if you are engaged in true mechanics lien litigation, that is a battle between innocents. You're trying to make a lender who has foreclosed on the property, a lender who has lost money on the project. You're trying to make that lender pay again for the brickwork you performed, even though they've already lost money on the project. And that is why that lender's going to hire a lawyer to fight your mechanics lien. So for planning purposes, don't count repair and warranty work. Count your 90-day deadline from your last new contract work. If you call me on the 88th day and you say, I'm going to ask you, well, when was your last work on the project? And if you say 88 days ago, I'm going to say, okay, let's go ahead and file a mechanics lien. It might work. But when it comes time to decide whether to enforce that lien, or when it comes time to decide how much you want to settle that lien case for, we're going to be focusing and talking a lot about the fact that we're relying on repair and warranty work. And so there's risk that a court's going to say that our mechanics lien was filed late. And so this is a lien we may want to sell cheap, is how we put it. We may want to settle the case at a lower value. Long periods of time with no work are also a danger signal that also comes from payment bond litigation. Federal payment bond case law is very clear that if you have been away from the project, have not supplied labor and materials for more than 90 days, and then you go back on the project and supply more labor and materials, you have bond rights for the new materials you are supplying, but you know it's too late to file a bond claim for the work that was more than 90 days old. I would be very concerned that a Maryland state court would rule the same way on a Maryland Little Miller Act case. Would a mechanics lien judge come to the same decision? I don't know, but I would worry about that. So for planning purposes, I want you just to remember, if you, I have clients tell me all the time, you know, well, when I say, well, you better file a mechanics lien, they say, oh no, we're going back later. We're going to do phase 2 later. And I always ask, well, how do you know you're going to go back? What if the owner runs out of money? What if the project is never restarted for some reason? You will have no security rights and may not be able to collect. So, I mean, anytime you've been away from a project close to 90 days, you need to think about going ahead and filing a mechanics lien. You can continue performance and you can explain to the owner that that's exactly what's going on. I'm going to continue performing my contract, but I need to file this mechanics lien to make sure I'm a secured creditor. And work performed in order to extend time. This is mechanics lien case law from Maryland is the only place I've seen this, but Maryland case law is very clear that if you go back on a project for the purpose of extending your mechanics lien rights, that does not work. That will not extend your mechanics lien rights. So in other words, I have clients sometimes tell me, you know, when I explain to them, oh no, if you've been gone for the project more than 90 days, it's too late to file a mechanics lien. You know, a client will say, oh, I know, I'll go back on the project and drop off some more material or put a couple nails in the piece of wood somewhere, and then I'll have mechanics lien rights. I have to tell you, no, that does not. No, you do not. Does not extend your rights. So at least make sure you don't, you know, tell me that when you're asking me to file a mechanics lien. I'm going to ask you a question. When was your last new contract work on the project? And if you say in 80 days ago, I'm going to say, okay, let's file a mechanics lien. All right. So this means you need some type of tickle system to monitor your deadlines and make sure you don't miss any deadlines. And again, this applies to bond rights and mechanics lien rights. It has to be some kind of mechanical system. If you're, especially if you're the owner or an employee in a small, closely held business, it can't be one person's job to just kind of remember all these projects and keep track of which ones are 90 days without being paid. You need some type of alarm system to operate. I do want to emphasize that the 90 days runs from the last day of supply, not the invoice date. That is a very common mistake that I've seen clients make over the years. And if somebody calls me, and this will always be a new client, somebody I don't know, they call me and they want to talk about filing a mechanics lien, I'm going to say, okay, well, what was your last day of work? And when they say, oh, well, it was 80 days ago, or it was 75 days ago, I've learned that I have to ask the follow-up question. Well, how do you know that? How do you know that? And often the answer will be, well, I'm looking at the invoice. And I'll say, well, okay, is that the invoice date, or is that what was the date that you supplied that material? And if you say, or the client says, oh, I don't know, I'll have to check that. And I've had this occur multiple times over the years, that when the client or the potential client goes and looks at their actual delivery tickets, they discover it was more than 90 days ago, and they're past time to file their mechanics lien. Remember that repair and warranty work does not count, or I would not count it for planning purposes. If the horse is already out of the barn, we talk about whether to give it a shot, but for planning purposes, does not count. So you need some type of mechanical computer system to track these deadlines. Material suppliers have an easier time with this. And one good system that I endorse is, I have clients that do this. A couple of stone supplier clients do this. The date of the invoice is the delivery date. Even if they send that invoice 3 days or 5 days after the delivery, the date on that invoice is the delivery date, not the date of the invoice was produced. And that way, if a credit manager is looking at a 30, 60, 90-day aging of invoices, they know they're looking at 30, 60, 90 days from delivery. And my general rule, if you're hitting 75 days after delivery, you need to start moving, at least start collecting information, get the project information sheet, Appendix 4 from the book, start collecting information. These are things you can do without incurring legal fees that will really speed up the process later and save you legal fees later and increase the chances of having an accurate mechanics lien later. Can be also very important to contact the general contractor or the owner and let them know you're working on your mechanics lien rights. Again, that's something you can do without incurring legal fees that may help preserve your security rights. Okay, labor and material contractors have a harder time, and because they've got punch list, and punch list, as long as it's new contract work, something you never did, punch list will extend your time to file a mechanics lien. There's a difference between punch list work and repair or warranty. I like to use the light bulb analogy to describe that. If electrical contractor is supplying all the light fixtures in a building, and the contract says they need to have light bulbs in every fixture in order to complete this contract. And the electrical contractor goes out on the site and screws one light bulb into a fixture, that is enough to extend their mechanics lien rights if there never was a light bulb in that fixture. If they installed a light bulb months ago and that light bulb got broken or the light bulb stopped working and they are now replacing that light bulb, now it's repair or warranty work. And it at least becomes arguable whether that extends your time to file a mechanics lien. But if that light bulb had never been there, then I don't have any trouble telling you that will extend your time to file a mechanics lien. Now, I would not advise you to rely on just a light bulb. Your lien rights will be stronger. Your lawyer will have an easier time collecting your money if we're counting your deadline from more substantial work. But I don't have any trouble telling you the correct legal answer is one light bulb is enough if it was not repair or warranty work. Okay, so labor and materials contractors, somebody has to plug that date in some type of computer system to track those dates. And I think, for example, one way you can do that is just buy a $100 copy of QuickBooks, or $200 it probably costs now, and just, or on your computer system, create an artificial electronic invoice or a tickle system of some type. And so one person in the company, one of the managers, it's their job to decide when to put that date in the tickle system. And it should be when you pull off the project and your crew is no longer going there every day or on a regular basis. That's the day you start the clock ticking and have an alarm go off after about 75 days to look at whether they need to preserve mechanics lien rights. Okay, let's talk about contracts and how many contracts you have can dictate deadlines, because you need to worry about the possibility that multiple contracts on a project will mean that you have multiple deadlines for filing a mechanics lien. And I'm thinking of Virginia case law here. The Virginia Supreme Court has ruled along the lines we're going to discuss. Actually, federal payment bond case law is similar. If there are two general contracts on a project, then there's going to be two different payment bonds and two different deadlines on the time to give notice of a payment bond. So Maryland mechanics lien law, I'm not aware of a ruling like this, but again, we're looking for the lowest common denominator. If you have more than one contract, I just want you to be aware of that when you're thinking about deadlines to move. And the example I like to use is what's often called a mechanical contract. Often the same company will perform plumbing work and the HVAC work, heat, ventilation, and air conditioning work on a project. Same company will often do that work. And sure, both of these contractors have mechanics lien rights or under both of these contracts. But the point is that installing toilets and sinks in the bathrooms indoors will not extend, well, excuse me, let me start over again. What's the last thing installed on residential projects? Commonly, one of the last things will be the air conditioning or the heat pump condenser unit that is put outdoors. That's because it's not really used until the new homeowners move in. You don't really need it. It's a valuable piece of equipment. You're worried about it being damaged during construction. So it's usually one of the last things to be installed on a construction project. And there's no question that installing that condenser unit outdoors is going to extend the contractor's time to file a mechanics lien for labor and materials under this HVAC contract. But the point is, installing this condenser unit at the end of the project will not extend the time to file a mechanic's lien for the toilets and sinks installed more than 90 days ago under this contract. So these labor and materials are going to run one deadline for a mechanic's lien. These labor and materials will run a separate deadline. There's no question that is the law in Virginia on mechanic's liens. That raises the question of extra work. What about extra work? Well, that question gives us an opportunity to note that extra work can be structured more than one way. Sometimes the first thing it says under an extra work order, sometimes the first thing it says is the following work is not a part of any existing contract. This is a contract separate from any other contract I have with you. I have noticed excavators often put that on their extra work ticket. And there may be good business reasons to do that. What the excavating contractor is really thinking is there will be no retention. The retention terms of our contract will not apply to this extra work, or the pay if paid portion of our contract will not apply to this extra work. I'm just going to do this work, you're going to pay me. Or you may even have to pay me in advance for this extra work or whatever it is. And that may be a good reason to do that. For our purposes today, I want you to realize that if you do that, now you have 3 different contracts on this project, and each one is going to run a separate mechanic's lien deadline. And as a matter of fact, in Virginia, what I would worry about, because of the Virginia Supreme Court case law, if you are an open account seller of materials, I think legally, each time the customer walks into your facility, or each time they call you on the phone and say, give me another load of stone out there, or give me, more lumber out on the project, each time that is another contract between that lender and that buyer. The contractor could have gone to any material supplier in town to get that additional stone or lumber. They're not required to buy from the same seller. Any given day, that seller could simply refuse to sell any additional material. There's no contract. The parties have not agreed, I'm going to supply all of the stone you need on this project on 30-day terms at the following prices. If there is a contract like that, now there's no question that each additional delivery will extend the time to file a mechanic's lien for all of the stone delivered to that project. But if it is open account sales, I would be afraid, I've never seen a court rule this way, but I would be concerned that if it was open account sales, that the law would perceive each sale as a separate contract running its own separate deadline. And so for that reason, material suppliers, just one thing to think about in setting up a project, you may want to have a blanket contract that's going to cover all of the sales on this project, so that you have more lenient deadlines for filing a mechanic's lien or a payment bond claim. And if not, you do have to worry a little more about tracking your deadlines. Okay, now, extra work order as a separate contract. The next thing to think about is that you could have structured this a little differently, where this extra work is a change order to the plumbing contract. And a change order is an amendment to the contract. The scope of work has changed in this contract now. The price to be paid has changed. And if this extra work is structured as a change order, now there's no question that this extra work will extend the time to file a mechanic's lien for all of the work under this plumbing contract. And then if you take this one step further, some of you may be thinking already, we could have just put all of the plumbing and all of the HVAC contract work in one contract, in one document, called it a mechanical contract. If we had done that, now there's no question that installing that condenser unit outdoors at the end of the residential project will extend the time for filing a mechanic's lien for the toilets and sinks that were installed early in the project, because it's all one contract. So anyway, you guys have various business reasons whether you want multiple contracts or one contract. What I care about is that you understand for planning purposes that the difference can impact your security rights. And I just want you to be aware of that for planning purposes. All right. In order to file a mechanic's lien, you also need a description of the property where your labor and materials were supplied. You're going to collect a copy of the building permit or a copy of the site plan before you ship, in order to make sure you have a good description of the property. But to take this a little further, what I need to worry about as a mechanic's lien lawyer, and therefore what you need to have some awareness of, is the number of parcels of real estate involved. You need to worry about off-site work. And an example I like to use is a stormwater retention pond. A stormwater retention pond is often not on the same piece of real estate as the building, the office building that's been built. Sometimes the stormwater retention pond is going to serve multiple parcels of ground. You can have a residential subdivision that there's a road running down the middle of the subdivision. Maybe that road is a public road. Well, that road is not on any of the residential parcels. Each of the residential parcels has a house, but if you supplied stone only in the road, you didn't supply labor or materials to any of the parcels of ground. And we need to account for that. We need to deal with that in filing your mechanic's lien. So if you do some work off-site, another example is street improvements. If you're building an office building on a parcel of ground, well, maybe the building is on the parcel, but you may also be doing curb and gutter work out in the public right-of-way. And we're going to need to account for that. You're going to have to tell me how much of your labor and materials was off-site and how much of it was on site. And so for our purposes here today, I just want you to understand that, because that's going to take extra time to figure out. So site development improvement contractors have a more complicated time with mechanics liens, and they can also have huge contracts. So it's important to worry about this stuff. Okay, we need the amount of the claim for each parcel of ground involved. And that's tracing is another word for this. You have to trace your labor and materials to each parcel of ground and tell me how the value of the materials you supplied to each parcel of ground. Delivery tickets are one way of doing this, and delivery tickets are very important for that reason. That delivery tickets must identify which lot the materials went to, not just which subdivision it went to. If it's lumber, for example, you know that lumber is going to end up on one particular parcel of ground. If you want to file a mechanics lien, you're going to have to tell me the exact value of the lumber that went into each of the 10 parcels of land on the property. One way you can do that is get a copy of the plans and do a takeoff estimation. That's will work. Another way you can do that is with delivery tickets that identify the exact parcel of ground. But one way or another, we're going to have to allocate your labor and materials to each parcel of ground involved. So you have a problem with counter sales where people are just stopping by your place of business. Your counter salespeople need to understand that they must request information about what lot, what parcel of ground are these materials going to, or at least management needs to understand you are deciding you will be an unsecured creditor. You are deciding you will not have mechanics lien rights for these sales. That's the decision management has to make. And if the sales are large enough that you do care about being a secured creditor, then your counter salespeople must be trained to request that information. And, you know, could the buyer give them false or incorrect information? Sure. But I would expect to win that as a lawyer if our evidence is, well, our counter salespeople are trained to carefully inquire about the exact parcel of ground where materials are going, and they are trained to accurately record the information when it's provided. And our records show that these materials went to lot 8 or whatever it is. I would expect to win that case on this issue unless the owner could come up with affirmative proof. Like I've had cases where an owner could show, well, if you look at the plans for this house, it would only use half the lumber that's claimed in this mechanics lien. But it would at least shift the burden of proof. Having counter sales fill in the lot number on the ticket would at least shift the burden of proof to the owner to prove that it's not accurate information. All right. Point of sale information is what the counter sales people need to record at the point of sale. Okay. One of the first cases I ever had, mechanics lien cases I ever had, a long time ago, involved building 1. I remember a client telling me we supplied materials to building 1. That's where all our materials went at this subdivision. And I said, okay. And the first thing I did, I got an address for building 1. And I did a title search. Mechanics liens are title search or land record based instruments. The legal description of the real estate is something you find in the land records, and a mechanics lien is recorded in the land records, and it must accurately recite the owner of the project. It must accurately recite the description of the real estate. And that's a lot of what I do for a living. One thing that means is that we have to make sure I have enough time to perform an accurate title search. And that's actually what takes the most time in preparing a mechanics lien. It's the reason why we can't do it on 24 hours notice usually, or it's going to be much more difficult to do it. So I received a request for a mechanics lien on building 1 in this subdivision. And I fortunately had enough time to do a title search, and I did. And I had to call the client back and say, I did the title search and I'm looking at the plat of subdivision in the land records. And so I have good description of the property, but the problem is building 1 is actually 1, 2, 3, 4, 5, 6, 7 separate parcels of ground. They're what we call townhouses. And that's exactly what townhouses are. Townhouses are very narrow parcels of ground that are subdivided. They might only be 14, 20 feet wide parcels of ground and 30 or 40 feet long, but they are separate parcels of ground. And I remember when I was a bricklayer, I used to, well, in those days, these internal party walls used to be block, cinder block. Usually nowadays, they're usually poured concrete, but we used to build these with cinder block. And I know as a mechanics lien lawyer, this is part of what we have to do. When I'm filing a mechanics lien on these 7 parcels of ground, this cinder block wall that's shared by 2 townhomes, half of this block is on each parcel of ground. And so you lien each parcel for half of the value of the block in that party wall. However, these exterior walls, the end units, long walls, that wall is entirely in this end parcel. This end wall is entirely in this parcel. These front walls are entirely on the parcel of ground. And that's how you have to allocate your mechanics lien. So if you supplied only the cinder block for all of the walls on these townhomes, the amount claimed in the mechanics lien for these 2 end units is going to be slightly higher than the other internal units, because these end units have more single walls, exterior walls. And so when I explained this to the client and told him I had done a title search and discovered there's 7 separate parcels of ground, I would tell them they need to allocate those materials between those 7 parcels. That might be easy, that might be hard. It's just something you need to be aware of, and I want you to be aware of. It's something that may take some time. You got to make sure you leave enough time to get that done before your mechanic. And if your mechanics lien is due tomorrow or today, that might make it impossible to file an accurate mechanics lien. How do you do the allocation after the fact? It's a takeoff. It's the same thing you would do in order to estimate the cost of a contract in order to bid on a project. You may have bid all of this as building one, or there's probably even multiple buildings and you bid it as 89 townhomes. But when it comes time to file a mechanics lien, you got to pull that same estimator into your office and explain to them that we need to figure out the exact value of the block and drywall and labor and materials that went on each of these parcels of ground. Okay, now, so we're still talking about allocation. Subdivision improvements can be type off-site improvements that can cause special problems. It can give you horrific allocation problems. A good example, the best example, are streets in a subdivision. Let's say there's one street that runs down the middle of a subdivision of 10 homes, 10 single-family dwellings. There's one street in the middle. You may supply stone for that street. You may supply asphalt for that street. You may supply electrical lighting to run along the street. That street might be a public road, and those improvements are going in a public right-of-way. That street might be on a common area. It might be a privately owned road that's owned by the subdivision homeowners association. In any event, it's labor and materials that are not on any of the individual lots. How are you going to be able to lien those labor and materials? This is a horrific allocation problem, and it's still a problem in the District of Columbia and Pennsylvania. However, in Virginia and Maryland, we do have some special statutes in the code, the state code, that makes this a little bit easier, especially in the case of Virginia. And the law in Virginia is very logical, and I've always been fond of it for that reason. If you supply labor and materials in the street for a subdivision, and there are 10 single-family dwellings, you get a mechanics lien on each of the 10 lots for 1/10 of the stone that went into that street. And if you think about that, that's kind of extraordinary, because the stone you supplied or the electrical fixtures you supplied are not on any of the 10 lots. And so this goes against the general rule of mechanics lien law, as we've been talking about the last couple of minutes. The general rule is you've got to figure out exactly what piece of real estate your labor and materials are on, and you only have mechanics lien rights on the parcel of ground where your labor and materials went into an improvement on that parcel of ground. That is the general tracing rule and allocation rule for mechanics liens. So it's really very helpful and kind of extraordinary that Virginia has this law that says, okay, even though none of your stone and none of your electrical fixtures are on any of these 10 lots, you just get a mechanics lien on each of the 10 lots for 1/10 of the value of the stone you supplied. That really makes your life a lot easier. In Maryland has a similar statute, but it's more limited in scope. The Virginia statute says something like anybody supplying labor and materials for improvements that serve all of the lots in a subdivision shall have a lien on in the fractional amount of those improvements on each of the lots. So it's very broad. It's for any improvement that serves all of the lots in a subdivision. The Maryland statute works similarly in that the liens spread around to all the lots, but you only have the right to do that for streets and for providing access, water or sewer. And so other improvements like lighting may or may not have mechanics lien rights. Now, on the Virginia statute, at least, I do also want to point out that this is one exception to the 90-day rule, the Fullerton rule. One exception was the mechanics lien agent notice has to go out within 30 days after you begin work on a residential project. Here's the next exception in Virginia. That is, if you are leaning for subdivision improvements, you must file your mechanics lien before the lot is sold. And that's actually, this is a priority issue we're going to get to a little later, but that's the only time your mechanics lien rights will not survive a sale of the property in Virginia is if your lien is for subdivision improvements. Okay, so offsite work in Maryland, DC, and Pennsylvania actually is questionable. Maryland, you're okay if it's for a specified improvement, which I believe is just streets, water, and sewer. DC, there's no statute at all. So we don't know if you have any mechanics lien rights for off-site improvements in DC. Pennsylvania is the same way. That work may or may not be bonded, but it's very questionable whether you have mechanics lien rights. And so that's just something I want you to be aware of. You may just be an unsecured creditor for that debt. Okay, remote subs and suppliers. There's a limit in some states, and this is a place that states will vary. There is a limit in DC and Pennsylvania. In the District of Columbia, you will have no mechanics lien rights unless you dealt with the owner or a general contractor. In other words, if you are supplying materials to a subcontractor or you are a subcontractor, you will not have mechanics lien rights in DC. You're just an unsecured creditor. And as a practical matter, that means that material suppliers are unsecured creditors in the District of Columbia. You just have to think of yourself that way. You just have to know that and be more careful in qualifying your customer, or you need to think about alternate security of some type. Think about getting an assignment of your customer's mechanics lien rights is a possibility that may help you. Requiring personal guarantees, requiring more payment in advance. But what I care about is you understand you're the credit card guy in that transaction and not the mortgage lender, and conduct yourself accordingly. Pennsylvania used to be the same as DC, where you had no lien rights unless you dealt with the owner or the GC. It now goes one tier lower in Pennsylvania. So second tier subs or material suppliers to a sub does have lien rights in Pennsylvania. If you're further removed from the owner, however, you will not have mechanics lien rights. So this is a difference between states. In Maryland and Virginia, it does not matter how far removed you are from the owner. In my belief, in Maryland, the case law is clearer. It does not matter how far removed you are from the owner. I think that's the correct answer in Virginia also, but there's not as clear case law in Virginia. You have lien rights. If the further removed you are from the owner, you're going to have more of a tracing problem. You may have a harder time proving where your material went. But if you can prove where your material went, you're going to have lien rights. And in Virginia, it's also more likely you're going to have a defense of payment problem, which might be the next thing we're going to talk about. Okay, yes, it is defense of payment. This is a difference in different states that is a significant difference. It makes a big difference in the extent to which you are protected. So you really need to be aware of this issue as you're moving from state to state. In some states, the owner is only required to pay for the project once. Once the owner has paid the general contractor in full, there's a defense to any mechanics lien filed by subcontractors or suppliers. The defense is, I paid, and I'm only required to pay for my project once. Here's my contract. Here's all the checks I wrote. I don't owe the general contractor anything. That is a defense of payment. The owner has the burden of proof. It is an affirmative defense, but if the owner can prove they don't owe the general contractor anything, the owner has a defense to any mechanics lien. Virginia and the District of Columbia have a defense of payment. Pennsylvania's a little complicated, but we'll get back to that when we get to the state surveys. And Maryland, there is no defense of payment as a general rule. I think this defense of payment really displays how mechanics lien law is a battle between innocents. Because why would you ever be arguing about whether the owner has paid for the project? The only time that's going to happen is if your contract debtor, the person you did business with, is out of the picture. They're insolvent. They don't have any money. They went out of business or they're bankrupt. And now a supplier or a subcontractor is trying to make the owner, or trying to establish a mechanics lien on the owner's real estate. And the owner may very well be in a position that they had paid the general contractor in full, or the general contractor had paid the sub in full, and they're innocent. And you're trying to make them pay a second time for the same labor and materials. That's a good example of true mechanics lien litigation that is a battle between innocents. If a lot of the mechanics liens I file are what I call glorified demand letters. I file the mechanics lien in the land records, the phone rings, somebody wants to send us a check. That's not true mechanics lien litigation. The owner's holding enough money on the general contractor's holding enough money on the sub. The mechanics lien claimant is getting paid without anybody losing money. And the money's just going where it was supposed to go. That's not true mechanics lien litigation. That's a glorified demand letter where nobody ever had to argue whether the mechanics lien was filed in a timely manner, whether the mechanics lien was properly allocated between all the parcels, whether the owner is indebted to the general contractor. None of those things became an issue because the owner was holding enough money to cover that debt. True mechanics lien litigation, very much bankruptcy is actually the same way. If you've ever wondered why bankruptcy is so complicated, it's for the same reason mechanics lien law is so complicated. It is a battle between innocent parties arguing over who's going to end up bearing the loss because of this insolvency. All right, how does a defense of payment work on a mechanics lien? And this is Virginia law we're looking at. This is what I call the contract tiers or the payment tiers, TIERS. Let's say the owner owes the general contractor $100,000. Let's say the general contractor owes the excavating sub $60,000. My client, the stone supplier, which I do represent a lot of stone suppliers, they're owed $75,000. Okay. They give me a call. I perform my title search as I always do. And I file a mechanics lien for how much? $75,000. I'm entitled to file a mechanics lien for $75,000 if that's what I'm owed. And the affidavit attached to my mechanics lien only says I swear under oath that I'm owed $75,000. That's a perfectly accurate statement. And I file that mechanics lien in the land records. Now time comes to enforce my mechanics lien. I file a bill of complaint to enforce mechanics lien against the owner of the property, the general contractor, and the excavating sub. To what extent is my mechanics lien going to be enforceable? Well, some people might say for the whole $75,000 because the owner is holding $100,000, but the general contractor also has a defense of payment. This mechanics lien is going to be enforceable to the extent of this $60,000 debt. My stone supplier client is going to get the whole 60 grand. The GC is going to be able to keep 40,000. My client's just out $25,000. My client can sue the excavating sub on the contract for that extra 25,000. And if this excavating sub is solvent, we will be able to collect it. But if this is true mechanics lien litigation, this excavating sub is out of the picture, they're insolvent. My client's going to get $60,000. They're just going to write off the other 25. The general contractor is not damaged by that. And that's how defense of payment works. Now, what if there's multiple suppliers to this sub? There's supplier number 2 also. Supplier number 2 is owed $150,000. Now what happens? When we're doing this seminar live, it's common for somebody in the audience at this point to say which mechanics lien was filed first. That's who would win first. And that's actually a pretty smart comment, because that's how most things in the land records work. That's how the priority of most liens filed works. Whichever mortgage was filed first is going to be the first mortgage. Whatever mortgage is filed second is going to be the second mortgage, and will have second priority. But that's not how mechanics liens work. The statute, the Virginia Code, is quite explicit that the debt held by this general contractor will be shared pro rata by all claimants that have valid mechanics liens. All right, so that's a good opportunity to point out that this is a place it's real important whether you preserved your mechanics lien rights and whether you did so in a valid manner, whether your mechanics lien is enforceable. You will share in this $60,000 asset. If nobody filed a mechanics lien, the bank that had a security interest in this sub's accounts receivable would get the whole 60 grand. But if my client was the only mechanics lien claimant, but we filed a valid lien for $75,000, we'd get the whole $60,000. But if both of these suppliers filed liens and they're both valid liens, they're going to share in this $60,000 pro rata. My client's only going to get $20,000 now. This guy's going to get $40,000. He's going to get 2/3 of the 60 because they've got 2/3 of the debt. We're going to get 1/3 of the 60 because we had 1/3 of the total debt. You can see I picked numbers to make my math easy, but that's how it works. Now, what if this supplier didn't have a good lawyer? Or what if this supplier just didn't want to spend so much money on a mechanics lien? What if they want to hire a lien filing service who'll do liens cheaper than a lawyer will? Well, usually it depends on which lien filing service it is, but they very often do not perform title searches or are not as careful about filing a mechanics lien. I did a title search before I filed this mechanics lien, and I saw that the property was owned by John Smith, LLC, a Virginia limited liability company. And I filed the mechanics lien identifying that LLC as the owner. Supplier number 2 just told his lawyer that, oh no, John Smith owns this property. Everybody knows that. He's out here on the site every morning telling everybody what to do. John Smith was the owner. And that lawyer filed a mechanics lien identifying the owner as John Smith. Well, legally, I have no trouble telling you that John Smith LLC is a different person than John Smith. John Smith LLC accurately identifies the owner of the property, not John Smith. This lien is fatally defective. This mechanics lien is fatally defective. It will fail. This mechanics lien is valid. And I tell my client, well, listen, I did a title search and I know this mechanics lien's invalid. And I know if I point that out to the judge is going to kick this mechanics lien out and you will get this whole $60,000. If we don't do that, if we just play nice and don't point this out, they're going to get 40 grand and you're only going to get 20. What do you want me to do, client? What's the stone supplier going to want to do? They want to collect their money. That's the credit manager's job. They want to collect as much money as they can. And I describe this example just again to show you that true mechanics lien litigation is a battle between innocents, and the defense of payment problem is a place that you see that. It's actually very unusual for mechanics lien claimants to fight about each other's mechanics liens. You're not usually going to do that, but I like to give that example just because you'll feel it. The people in this audience will really feel that, and you'll understand the battle between innocents problem. Okay. If there were no mechanics liens, that $60,000 would go to the accounts receivable secured lender, the bank that had a security interest on all of the excavating subs receivables. If there was no such bank, that $60,000 would be shared by all general unsecured creditors in the bankruptcy. And in real life, general unsecured creditors get paid very little or perhaps nothing, and that $60,000 would just be eaten up by administrative expenses, the trustees' fees, and the different lawyers involved in the case. You must have a valid mechanics lien to claim any part of that asset. A mechanics lien only gives you a claim to that one asset, the accounts receivable owed to your debtor, your contract debtor, for supplying labor and materials to that particular piece of property. And you must make sure you have a valid mechanics lien to do that. So mechanics lien claimants are actually adverse to each other, and it is a battle between innocents. Okay, this is the true deadline for filing your mechanics lien in Virginia and the District of Columbia. Whatever day the owner pays for in full for the project, everybody's mechanics lien rights go out the door. When's the owner going to pay the GC? We don't know. So you don't know your real deadline. In our business, it's not usually a problem because of retention and because owners tend to hold money a very long time before they let go of it. But it can be an issue, and you want to have some awareness of the status of accounts going upstream. It's also a good opportunity to point out this is the greatest limiting factor material suppliers have in Virginia to their mechanics lien rights. Number one, you know, if you're supplying a sub, or even worse, you're supplying a sub materials, you're 3 or 4 tiers removed from the owner, you will have a tracing problem, which we talked about. But you know, you may be able to prove where your materials went, but there's a greater chance of there being a break in the payment chain where there's no debt, and it will cut off all mechanics lien rights below that. And I guess that's a good opportunity to explain the defense of payment can come because of actual checks written, because of payments that were made, but the defense of payment could also occur because of some breach of contract by a mid-tier contractor. In other words, the general contractor might have huge back charges against your contract debtor. You're supplying material to a sub. The general contractor has huge back charges against that sub, so that general contractor does not owe any debt to that sub. Well, that is going to cut off your mechanics lien rights. And so that's actually one thing I do for a living. That's an example of a battle between innocents that can get very expensive. You know, you may dispute, you as a material supplier end up stepping into the shoes of your contract debtor. Your contract debtor may be out of business, and you step into the shoes of the contract debtor and fight the general contractor about their back charges in order to prove that, no, you do owe the subcontractor some money, and therefore my mechanics lien is actually valid. You do not have a defense of payment. You have the burden of proof of proving you don't owe any debt, and you have failed to do that. I can prove you do owe money. Okay, the more removed you are from the owner, the more likely you will have a problem. That is the biggest limiting factor for mechanics lien rights for material suppliers in Virginia. You must know whether you are in a defense of payment state. Virginia, DC, and usually Pennsylvania do have a defense of payment. Maryland usually does not. And it's also a good opportunity to talk about the practicalities of freezing money. And this is the reason it is so important for you to collect information about the name and address of the owner and the name and address of the general contractor before you ship materials to a project. You know, a general contractor, if you think about it, will never have a defense of payment problem. However much money the owner owes them, the GC has valid mechanics lien rights for that dollar amount. A subcontractor has defense of payment problems if the owner doesn't owe the GC anything, but GCs might be stronger financially. A supplier to a subcontractor, however, is at more risk of having a defense of payment problem. And they're also further removed, so they may not know who the owner is. They may not know who the general contractor is. If they don't know, how are they going to be able to contact them and tell them they're not getting paid? And if we were in a live audience and we had general contractors in the audience, I would typically ask the question, you know, of one of the GCs, if you receive a phone call or you receive a letter from a remote supplier saying you're not being paid on a project, what effect is that going to have on your payments to that subcontractor? And the point is, most GCs, if they know a supplier is not being paid on a project, most GCs will freeze payments to the sub until that situation is resolved. And so if you are able to contact an owner or a GC and tell them that you're not getting paid, that's going to preserve your mechanics lien rights in Virginia and DC, even if there is no defense of payment, like in Maryland. As a practical matter, it's going to make it a lot easier. It's much more likely you will never even call me. You won't need a lawyer at all. You're just going to get paid if you can contact the owner and the GC and tell them you're not being paid. How are you going to do that if you don't know who the owner is? And so the defense of payment explains why it's so important for a remote contractor or supplier to collect information about the contractors, the players on the project. All right. This brings us to the priority of mechanics liens, which sounds very lawyerish, and it is sort of, but it, to me, it's academically very interesting, and it certainly is an important issue in the strength of your mechanics lien rights, and it does vary from state to state. What we're talking about is, what if the real estate is sold where you supplied labor and materials? Does your mechanics lien survive a sale of the property? That's a priority issue. What if the owner files bankruptcy? Do you still have mechanics lien rights? That is a priority issue. Who wins in the event of a foreclosure or in the event of a bankruptcy, either one? Does the construction lender, the bank, the mortgage lender, have priority over the mechanics lien claimants, or do the mechanics lien claimants have priority over the construction lender? That is a priority issue. And that is the single biggest priority issue in Virginia. And that's the single biggest difference between Virginia mechanics lien rights and mechanics lien rights in almost every other state of the Union. Now, priority, as we mentioned a few minutes ago, the priority of various liens recorded in the land records is generally in the order of recordation of those mortgages. Whatever mortgage is filed first is the first mortgage, and they get paid first. Whatever mortgage is filed second in time is the second mortgage. It doesn't say second mortgage, or it doesn't have to say second mortgage on it. It usually does not. You know it's the second mortgage just because it's the second in time that was recorded. Mom and dad went to settlement on their FHA loan or whatever it was, and then the telephone started ringing, and it was second trust lenders saying, we'll lend you another $10,000. All you got to do is sign this second mortgage, and you can use this credit line for anything you want. That's a second mortgage because it was recorded second in time in the land records. Priority can easily determine whether the lender collects anything in the event of default. Let's say there's a townhouse with $100,000 fair market value. Well, if the appraised value is $100,000, a conventional first trust lender is only going to provide an 80% mortgage if the property is worth $100,000. So they're going to lend $80,000. That second trust lender may lend another 10%. They may lend to 100% of fair market value. They may lend at 95%. That depends on how much risk they want to take. But they will lend some additional amount. What if there is a foreclosure on that property? And, you know, it depends. It was a little different in the subprime loan crisis, you know, but I'm simplifying things to help you understand priority. In a townhouse with $100,000 fair market value might only bring $85,000 in a foreclosure sale on the courthouse steps. Well, that may or may not be enough to cover this first mortgage debt. that first mortgage says right in it that this mortgage will also secure the trustee's fee, will also secure past due interest on the mortgage, will also secure any money the lender has to pay in order to maintain the property. So what was an $80,000 mortgage is now an $87,000 mortgage because of those costs. This first mortgage lender is going to get almost all that they're owed, but even they don't get paid in full. The second mortgage lender will receive nothing. So that's an example of where you can have a perfectly valid lien, a perfectly valid mortgage. You are a secured lender, but you are under secured. There's just not sufficient equity in the property for you to get paid. So taxes would be paid first in this example, no matter when the tax lien was recorded. And that's because the ruler always gets paid first. But that is an example of a super priority lien, is the main reason I bring it up, that these taxes didn't become due. There was no record of those taxes, and it could be years after these mortgages were recorded, but they're still going to get paid first. That's an exception to the recordation rule, first in time. There are other super priority liens in addition to tax liens, and they are mechanics liens in some states have super priority. We've already talked about one example of that, the defense of payment in Virginia. It does not matter what order the mechanics liens are recorded, they're going to share pro rata in that $60,000 receivable. The priority of mechanics liens is something that does vary significantly in the different states in which I operate. The highest priority lien is in Virginia. There's no question. The Virginia mechanics lien has priority over all other liens filed in the land records, except for the bank lender to the extent of the value of the land. In other words, a simpler way of putting it, which is almost 100% accurate, but it is just a much easier way to understand it. In Virginia, the bank has the first priority lien on the undeveloped land, the dirt. The Virginia mechanics lien claimant has the next highest priority over all of the value of the land and the improvements. In other words, let's say there's one bank who's the lender to buy the ground and to build the building. And now the whole building's been built and the owner of the property becomes bankrupt. And so mechanics liens are filed. It's a true battle between innocents. And we're going to fight about whether the lien was recorded on time, whether it accurately described the owner and the real estate. And now we're arguing about priority. And the argument's going to be about what is the value of the vacant ground at the time the project began. And the bank's going to have first priority to the proceeds of foreclosure to the extent of that value. And then the mechanics lien claimant will get the rest until the mechanics lien claimant is paid in full. If there's anything left, it will go to the construction lender. That's the priority of a Virginia mechanics lien. The highest priority of any lien except the tax lien or the purchase price of the land. The next highest priority lien in this 4-state area is the District of Columbia and Pennsylvania. Is very similar. It is an inchoate lien, which we'll talk about in a minute. The difference is the construction lender does take priority for all they are owed, not just the value of the land, but the construction lender will then get all of the proceeds of foreclosure until the construction lender is paid in full. If anything's left, the mechanics lien claimant gets it. So that difference in priority is a big difference in the event of insolvency. And it means that if it's just an insolvency by one subcontractor on a project, the priority is not going to be a problem. Defense of payment might be a problem, but priority of the mechanics lien will not be. It would really only come up in the event of insolvency of the owner. The entire project fails. There's going to be a big difference in the strength of the lien rights in Virginia compared to DC or Pennsylvania. The weakest priority in the 4-state area is in Maryland. Maryland, the priority of the mechanics lien is the same as a judgment lien. So you're really in the same situation as an unsecured creditor altogether. You don't have a lien until you file suit, until it goes all the way to court. The judge says you win and establishes your mechanics lien. And it wouldn't, if you think about it, it actually wouldn't matter. If you had a contract with the debtor, it wouldn't matter whether you had, if you had a contract with the owner, it wouldn't matter whether you had mechanics lien rights or not, because you could sue the owner. Once you got a judgment against the owner, it would attach as a lien to real estate owned by the owner. And it's the same lien you would have as a mechanics lien claimant. Same as a judgment lien. What difference does it make? The DC, Pennsylvania, and Virginia mechanics lien are inchoate. That means that's a Latin word, and I don't usually like to use Latin terms when I'm talking to non-lawyers, but there's no direct English translation. It means something like relates back to the commencement of work. It's as if you recorded your mechanics lien the day the project began. And if you think about it, any lender who's going to lend money on the project, or anybody who's thinking about buying the property, they have notice. If they go look at the property and they see construction activity taking place, that's their notice that there may be a claimant. So it's okay that nothing's filed in the land records yet. That potential lender or that potential owner knows that there may be mechanics lien claimants. Lien relates back in time. How does that work? Relates back to the commencement of work. There's a timeline. Here's where work starts. Early this morning, we talked about here's your last work, your last new contract work. You must file your mechanics lien within 90 days of your last new contract work. Well, what if the property sold right here? How does that work? Before the lien was filed, but within that 90-day period. you must still, in Virginia, you must still file a mechanic's lien. You must properly identify the owner in that mechanic's lien. In other words, your mechanic's lien must identify the new owner. But if you do that, your lien relates back to the date that work started, and any changes in the title to the property after that are subject to this claimant's mechanic's lien rights. They have to have valid lien rights. They have to file a valid lien. But if they do that in a timely manner, they can force the new owner. And that's a real good example of a battle between innocents. A completely innocent owner who paid in full for this piece of property, the mechanic's lien claimant can force that owner, that new innocent owner, to pay for labor and materials again that the owner's already paid for once, because the mechanic's lien rights survive a sale of the property. That's exactly why when you're buying a property, everybody the seller is signing affidavits, swearing under oath that they haven't ordered any work in the property in the last 90 days for which they have not paid. And it's why everybody's so worried about lien waivers. And it's why the bank and hopefully the owner of the property, if they are getting good legal advice, they purchase title insurance on the property to insure against mechanic's liens and to give them insurance so they won't get hurt if there are mechanic's lien claimants. And that's a lot of what title insurance companies, that's a lot of their industry. What they do is take the risk of mechanic's lien rights. What if bankruptcy is filed in this same time period? It's the same situation. It's just like a sale. If the lien relates back to when work begins, it will have priority over the bankruptcy trustee. The mechanic's lien will survive the bankruptcy. The mechanic's lien claimant will be a secured creditor. So an inchoate mechanic's lien survives the sale of the property, survives bankruptcy. It is not a preference. If a bankruptcy is filed right here, I can march right down to the courthouse and file a mechanic's lien tomorrow. I don't need relief from the bankruptcy court, relief from the state to do that. I always had mechanic's lien rights. So I don't need relief from the stay. I'm not improving my position by filing that mechanic's lien. You always had the lien. That's what it means to have an inchoate lien. If the lien is not inchoate, a sale of the property destroys lien rights. And this is the greatest limiting factor probably of mechanic's lien rights in Maryland, particularly residential properties. The case law in Maryland is that if the property is even just under contract and hasn't gone to settlement yet, the mechanic's lien claimant, the purchaser, the contract purchaser wins. They have higher priority than the mechanic's lien claimant. And if you think about it, with residential properties, builders usually won't even start construction until the property's sold, or the property is going to be, by the time it's finished, it's going to be sold. And so as a practical matter, you're not usually going to have mechanic's lien rights on residential property in Maryland. In Virginia, the mechanic's lien agent statute is similar, causes a similar problem for residential property. But anyway, back to in Maryland, you don't have mechanic's lien rights until you file your petition to establish and enforce mechanics lien. It gets all the way to trial. You win. The court establishes your mechanics lien. In Maryland, if the owner files bankruptcy within 90 days after that judgment, the mechanics lien rights are lost. In other words, you don't have mechanics lien rights. It might be 2 years after you finished work on the Maryland project that you went without having mechanics lien rights, waiting for this case to get through the court. And now, after doing all that and paying $100,000 in legal fees, if the owner goes and files bankruptcy 88 days after the court rules in Maryland, you've just wasted the last 2 years and $100,000 on that mechanics lien case. That's a priority problem. All right, so let's talk about the different states. We're doing pretty good on timing. We might even finish a few minutes early. Let's bring together all the things we're talking about. Now I'm going to focus on the 4 states. And I think almost everything we're going to say here will be a repeat of what we've talked about. We've talked about these concepts. Now we're just going to summarize and remind you what this means for the different states. Let's talk about Virginia first, since that's where I'm sitting. Your actual deadline, and I don't want to waste a lot of time with this, but the actual deadline to file a mechanics lien in Virginia, the statute, this is right out of the statute, which proves this is the way the law is. It's hard to read. Within 90 days from the last day of the month in which the claimant last performs work, but not later than 90 days from completion of the entire project. Let me translate that for you. That means you have between 90 and 120 days after your last work. Somewhere in there is going to be your deadline if you are a sub or supplier. But if you happen to be the last sub or supplier on the project, well, here, I'm sorry, let me start over again. For most of the time, if you're a supplier on the project, whatever month your last supply was, you go to the last day in that month, and then you count 90 days, not 3 months, 90 days from the last day in that month is going to give you your deadline. If you think about it, that means if it doesn't matter whether your last supply was June 3rd or June 30th, your deadline is going to be July, August, September 28th or 29th. And your deadlines are usually the 28th or 29th of a month, except February screws things up because there's only 28 days in February, 90 days from the last day of the month. If you think further about it, that also means a general contractor in Virginia, and that means anybody who has a contract directly with the owner, is always going to have a straight 90 days, because whoever the last supplier is, whoever the last subcontractor is, whoever the last person is doing any work on the project, if that's the last work on the project, there's going to be a straight 90 days for everybody. So that's complicated. You might have more than 90 days, but look at it later. Put your deadlines, your tickle system, your alarm clock, set it at 90 days. You might have a few more days when you look at it. Means you have a minimum of 90. The Virginia lien is a land record-based lien. You must have a title search. Tax assessments is not 100% accurate land record information. Googling stuff on the internet is definitely not accurate. You need a title search. A title search is the biggest timeline item in preparing a mechanics lien. We need a few days to do that. And one thing I encourage clients to do you can call us and I will promise to do nothing but hire a subcontractor to go do the title search. And they're usually just going to charge a couple $100 or something. And I'll promise we won't do anything else. We'll just order that title search. But then we'll have it here. If we have the title search, now we can prepare a mechanic's lien on 48, 72 hours notice, get it signed, get it recorded, no problem. But, you know, we really need a week or 10 days if we don't have the title search yet. Okay. You must enforce your mechanic's lien within 6 months after filing the lien. So if your lien was due September 28th and you filed it on September 28th, your bill of complaint to enforce mechanic's lien would be October, November, December, January, February, March 28th. Exactly, not 180 days, 6 months later. But of course, you've got your attorneys involved by then. So you got to worry more about the deadline for the mechanic's lien. Okay, Virginia projects, there is a defense of payment. That's the biggest limiting factor for remote suppliers and the biggest chance of a problem. There's no known limit on remote claimants. Does not matter how far removed you are from the owner, but the more removed you are, the greater the chance there's going to be a defense of payment. 150-day rule, I'm not going to spend a lot of time on because it rarely matters. It is described in some detail in the book, but it really old work. There's two deadlines that work off of your last day of work. The deadline we've been talking about is you got to file your mechanic's lien within 90 days of that last work. But the other deadline is your lien can only include labor and materials supplied for the 150 days prior to that last day of work, except, and this is why it doesn't matter so much, except for retention or money held due to a pay when paid clause. So the general rule is really, you can't wait more than 5 months. You shouldn't supply labor and materials on a project for more than 5 months without getting paid. Well, that's kind of like, duh, when's anybody ever going to do that? And the answer used to be, you're going to do that with change orders. And that's where a problem was. Retention was always explicitly excluded, but change orders were still a problem. They amended the statute, I forget when, 10 years ago, where it says that if money's held because of a pay when paid clause, the 150-day rule doesn't apply. That eliminates the problem most of the time. Okay, you do have a mechanic's lien agent pre-notice for residential work. You don't have to worry about it if you're doing the streets, the sewers, anything that serves the whole subdivision, but anything that goes on an individual lot, you have to send a mechanic's lien agent notice. I would encourage you to look at the book about that. It is impossible to waive your mechanic's lien rights in a contract in Virginia. But there can be that provision may make a pay if paid clause null and void in Virginia. I say may because there's no case law on this, but this is a fairly recent change in the Virginia statute. And it says something like any provision in a contract that diminishes mechanic's lien or bond rights is null and void as a matter of public principle. This is the sort of thing lawyers argue about for a living. Wouldn't a pay if paid clause diminish your mechanic's lien and bond rights on a project? I think so. I've never seen that argued in court. I'm waiting to see it argued in court. I'd be happy to take a case all the way to the Supreme Court for you if you want to know the answer. All right, Maryland projects. All claimants must file a petition to establish and enforce the lien within 180 days of claimant's last work. That's all. It doesn't matter whether you're a GC, a sub, a supplier, it doesn't matter. You must file your lawsuit to establish and enforce your lien within 180 days of your last work. If you do not have a contract with the owner, if you are a sub or a supplier, you have an additional deadline. You must mail a notice of intent to lien within 120 days of your last work. So you have more time in Maryland. You only have this additional deadline if you're not a GC. This notice is not filed in the land records like it is in Virginia. It's not a land records-based lien. It's a demand letter. It's a notice that you must mail to the owner, and you have to do it. Maryland projects, there's no defense of payment. The priority of the mechanics lien is going to be the problem in Maryland. But the good news is you can make the owner pay twice for the same labor and materials, except if an individual is building a residence on the individual's own lot. So if I buy a lot and I'm building my own house there, I will have a defense of payment for that project. But if I'm a builder building houses for other people, there is no defense of payment. All right, there's no known limit on remote claimants. There is explicit case law on that in Maryland. Does not matter how far removed you are. You got the 15% rule on owner work, 25% on tenant work. Again, I'm not going to spend a lot of time on this. It's discussed in detail in the book, but the short version is small renovation or repair projects. Nobody has mechanics lien rights. The contract, the project must improve the value of the property 15%. If the owner ordered the work, must improve the value of the property 25%. If the tenant ordered the work. So this can be a problem if you're doing tenant work, tenant improvements in commercial properties, the 25% rule can be a problem. It is impossible to waive lien rights in the contract in Maryland, just like Virginia. The Maryland statute explicitly says a pay if paid clause does not defeat lien rights in Maryland. So in Maryland, if there's a pay if paid clause in the contract, it gives the GC a complete defense to a contract action. And if a sub sues the GC on the contract, there will be, they will fail because the pay if paid clause defeats contract rights. But if that same lawsuit is filed as a petition to establish and enforce mechanics lien rights, that will succeed, which has the same effect. The general contractor will pay that mechanics lien claim because otherwise they'll be in breach of the contract with the owner. All right, Maryland projects, a sale of the property defeats lien rights. For that reason, there's not really residential mechanics lien rights in Maryland. Bankruptcy of the owner defeats lien rights. Trust fund statute survives, that's a different seminar, but there's a different, that's your saving grace in Maryland in the event of a bankruptcy is the trust fund statute, which is a separate chapter in the book that I invite you to look at. All right, DC, the deadline to file a mechanics lien is within 90 days of completion of the entire project, not 3 months, 90 days. of the entire project, not just your work, the entire project. So that's a very liberal deadline. You might still have mechanics lien rights in DC 2 years after your last supply on the project. If you're an early excavating sub who, or stone supplier that supplied material early in the project and the project's been going on for 2 years, you may still have lien rights. There may be defensive payment problems, there may be other problems, but you still have lien rights. The DC is a land record-based lien, so you need a full, careful title search, and that's actually not easy to do in DC. You need to make sure you got a good title companies to do that for you. Another problem in DC, the clerk gives you a much harder time in DC. You must show them a copy of your license, contractor's license. You must show them a certificate of good standing that you've paid all taxes you owe in the District of Columbia. These are revenue provisions. It's just how they make sure they get all the money they're supposed to get. But this can be a problem, particularly with material suppliers, and we end up arguing with the clerk on a lot of occasions that, wait a minute, we just shipped these materials from Wisconsin to DC for this construction project. We're not doing business in DC. We're not required to have a contractor's license. This is part of what we do for a living, getting liens recorded in DC. But needless to say, and this is true in all the states, if you are an on-site sub, you must have a contractor's license, or you will not have mechanics lien rights. It's the least of your problems. You won't even be able to sue on your contract if you're doing construction work without a license. All right, you have to enforce your lien within 180 days after filing that notice of lien up here. There is a defense of payment in DC. There's no sub lien rights. That is the biggest limiting factor for material suppliers in DC, lien rights. Okay, Pennsylvania, very liberal deadlines. You can file your lien claim within 6 months of your last work. Subs must serve a formal notice. It's kind of like Maryland. The deadline everybody has is you got to file your lien claim with the clerk. That's not in the land records. It's filed with the clerk of court within 6 months of your last work. In addition to that, if you do not have a contract directly with the owner, you must send a formal notice on the owner at least 30 days prior. So if you're a sub, your real deadline's 5 months, not 6 months is one way of looking at that, but it's a liberal deadline in any event. You must enforce your lien claim within 2 years of the lien claim. So you could be in litigation, you could be filing your lawsuit to enforce 2.5 years after your last work. That's pretty liberal deadline. Okay. Pennsylvania, there's no defense of payment. You can make the owner pay twice, except any residential project, or if a payment bond is supplied, or the general contract is recorded. Now you're fine if the owner requires a payment bond or the GC supplies a payment bond in order to avoid having to pay twice for the same project. You're fine with that because you have security against the bonding company. However, they have another choice. They could record a copy of the general contract with the clerk before they start construction. And if they do that, it creates a defense of payment. So if you're supplying labor and materials in Pennsylvania, one thing you might think about doing is having a look at the land records before you start work. It's kind of like you need to check the building permits in Virginia for residential projects. In Pennsylvania, you definitely want to check that internet site. We'll get back to in a minute, but you may also want to check the clerk's office, see if a general contract was recorded. There's no third tier sub lien rights in Pennsylvania. GCs can waive lien rights for all lower tier subs on residential projects and on all projects if the GC posts a payment bond. That's the same thing we're talking about up here. Okay, after 2017, so it's been 5 years now, there's a directory available online that we looked at before. Any project that's more than 1.5 million is a searchable project, and there will be, the owner can post a notice of commencement, and they will, because the bank's going to require it. Whoa. Oh, I just messed things up. Hold on. I shared screen on the wrong screen. Where am I now? Oh, Lord Almighty. Fuck. Wow, I have never had that happen. Oh, here it is. Okay, sorry. Share screen. All right, we're back. If it is a searchable project, the project owner may file a notice of commencement on the directory. It must be filed prior to work beginning. Chapter 12, page 4 of the book will tell you what has to be on it. The notice of furnishing that a claimant would have to file, they only have to do if the owner files a notice of commencement. So if you go look at that website, there's no notice of commencement, you're done. But if a notice of commencement's filed, you must file your notice of furnishing within 45 days of your first work. Page 5 of that chapter will tell you what must be on it. The project owner can file a notice of completion, but it doesn't really matter. It's not a required notice, and it does not impact mechanics lien rights. You can file a notice of non-payment, but again, there's no deadline. It's not a requirement. May have practical benefits. I have yet to see where it does. And here we got this deadline summary. This is Appendix 32 of the book. You can get it on the website, and I would encourage you to do so and print it off. And the next appendix is a similar thing for bond rights. It gives you the 4 states and the stuff we've talked about just in the last 10 minutes on Virginia, Maryland, DC. You know, this one 8.5 by 11 sheet of paper gives you most of the differences between the different states. Okay. So there is our mechanics lien rights seminar. We're gonna do payment bonds. I believe it's November 17th, but it's on the website. I'd have to look at my calendar. Excuse me, October 17th or 27th. I ought to know that. Sorry, hold on. Let me get that sound file. Yeah, 27th, October 27th, which is a Wednesday. We're going to do payment bonds, and we will do lien and bond waivers that day. So you'll want to watch that, at least the end of that, to learn about mechanics lien waivers and payment bond waivers. Really work the same. Let me see, we got a chat here. Let me see what we got. Okay, that's a thanks. Do we have any questions? You can send me a chat, or anybody can unmute now if they want to. Security, allow participant. Okay, you're allowed to unmute yourselves now, I believe, if you have any questions. And you're allowed to chat, you're allowed to unmute, you're allowed to start the video. Wow, we don't have very many people with video, but at least I see who's here now. Christopher's here, Teresa, Well, I would be grateful if all you guys send me an email, and just so I know who's here and who isn't. That's at jfullerton@fullertonlaw.com. Oh, Douglas Stringer's here again. He's got a good picture. Camel is still here. Andrea, hopefully that seminar was helpful to you. I don't see any questions coming in. Nobody's unmuting except Michael Keegan. What do you got to say for yourself, Michael? Christopher. Okay, so we're done. Thank you very much for attending. I look forward to seeing you October 27th to talk about payment bonds and mechanics lien and bond waivers. Thank you.